Good morning, everyone. Welcome to a 2-hour webinar this morning. We are happy to have you with us today. This is a joint program brought to you by Boltman Financial Services and Wisconsin Lawyers Mutual Insurance Company. I'm Tom Watson, Senior Vice President at Wisconsin Lawyers Mutual Insurance Company, and I would like to not only welcome you to the program, but also give you a couple of pointers as to how you can navigate through the program today as we go forward. As I said, it's a 2-hour program. The first hour will feature Corinne Boltman, and Corinne will be talking about Medicare issues, and the second hour will be Matt Beyer and Brian Anderson from Wilmick on malpractice issues. A couple of things. On your screen, you will find the materials or a link to the materials on the right side of your screen. You can click that and call up the materials as you wish. Corinne will have a PowerPoint presentation on your screen for you during her presentation. And there is also a tab called Ask the Speakers. And if you click on that tab, you can type in the chat box your question or comment anytime during the program, and then click send, and we will get it, and our speakers will address your question for you. Normally, this program is brought to you in person, and it's been going on for many years. Boltman has been around for 26 years, Wilmick for 34. We at Wilmick have been honored and privileged to be part of this program from time to time with Boltman. And as I say, in past years, it's been in person. We wish we could do that again, but with this pandemic, this is the next best thing. So here we are virtually, and we certainly appreciate you participating. With no further ado, the first hour on Medicare and other issues, Corinne Boltman from Boltman Financial Services. Corinne, good morning.
Good morning, everybody. This is an interesting experience for me. I've never done a Zoom presentation. It's actually extraordinary because normally we have about 50 people attend our presentation, and we apparently have 300 people signed up. So that's pretty awesome, and I hope that we'll have some informative information for you. Today I'm doing an educational presentation on Medicare. As you can see, this presentation is branded from United Healthcare, but none of the materials that I'm presenting today are product specific or carrier specific. This is just general information about how Medicare works, and I find that it applies and is relevant to people for their own experience as they transition onto Medicare, but also helping deal with adult parents and also aging parents and also clients as they are, as you're advising them as they transition onto Medicare. So the presentation is called Medicare Made Clear. And like Tom said, that normally this presentation, I allow for questions to be asked during the presentation. So if you would like to send Tom a question, we certainly I can address your specific questions as we go. So first slide, what is Medicare? Well, Medicare is a federal health insurance program. It is considered a social program for retirees or people over age 65 most of the time. And it is funded in part by taxes that we contribute through payroll, FICA tax. And it is health insurance. And who qualifies for Medicare? Like I said, most people who are on Medicare are over age 65 or older. You can be U.S. citizens and legal residents who have resided in the United States for at least 5 years in a row prior to qualifying for Medicare can enroll. And certain people who have been on Social Security disability for at least 24 months qualify for Medicare. Also, people who have end-stage renal disease or ALS qualify to enroll in Medicare. So what does Medicare cover? Well, original Medicare consists of Medicare A and B. And Medicare A is hospital services. Those include the services that you would receive when you have an inpatient hospital stay. For the most part, it's all of the services you would receive in an inpatient hospital stay. It also can include rehabilitation services you receive at home after a hospital stay. And it can also include medications that you receive while you're experiencing a hospital stay. And that will kind of make some more sense why I break those things out as we move forward in the presentation. So for most people, Medicare Part A has no cost because we all contribute into Medicare Part A through our FICA taxes for if we have been working for at least 10 years. Medicare, original Medicare is, you can't be denied. It's not exactly accurate to say it's guaranteed issue because it's not really issued. You're eligible to enroll in it. And Medicare A and B, original Medicare, everybody is accepted regardless of their health status. Original Medicare includes all doctors that accept Medicare anywhere in the country. Sorry, I'm just looking at the slide. This is a little different to have it side by side. So you can't be denied for Medicare Part A, and it includes, like I said, inpatient hospital stays. And there's an issue that's cropped up somewhat recently about your status when you're in the hospital. So you have to actually be admitted. You can't be in observation status to have Medicare Part A cover your claims when you're in the hospital. Medicare Part B is outpatient services, and that includes anything that you would have, any medical services you would have while you're not admitted in the hospital. So for the most part, most of us receive our medical care through outpatient services. That's doctor visits, any type of laboratory testing, x-rays, therapies, mental health care, outpatient surgeries. So all of those things are a part of Medicare Part B. Again, you can't be denied to enroll. And everyone who is on Medicare Part B, unless they are very low income, is subject to pay a Medicare Part B premium. And the Medicare Part B premium is income-based. So most Medicare beneficiaries pay the standard Part B premium, which is $144.60 in 2020. But people who are higher income earners can be subject to higher Part B and D premiums. And so that income threshold where people start to be subject to something called the income-related monthly adjustment, that is $87,000 for people who are single and $170,000 for people who are married. So Medicare doesn't cover everything. It does cover all of the things all of the services that you need that are medically necessary, but it does have out-of-pocket expenses in that you can be subject to excess charges. So some doctors accept Medicare assignment, but the law allows that they can charge up to 15% more than what Medicare reimburses. Medicare original Medicare A and B does not cover drugs. That's why people have to enroll in a freestanding drug plan, a Medicare Part D plan. And it doesn't cover some of the things that, a lot of us regularly use, like eyeglasses, contact lenses, hearing aids. Medicare does cover the care and treatment of your eyeballs, for lack of a better way to explain it, but it doesn't cover care for your vision, so not a vision exam and no glasses. And it does not cover custodial care, and that's very important because although some skilled nursing or some rehabilitation services are covered and those can be received in a nursing home, you have to qualify under Medicare to receive that care. If you're not rehabilitating or recovering, then that is when the long-term care becomes custodial care, and Medicare does not cover that. So, what are the costs that you can be subject to when you're on Medicare? You can be subject to a premium. So everybody is going to pay a Part B premium unless they're very low income, regardless of what insurance you purchase to cover the outpatient costs or the out-of-pocket costs that Medicare doesn't cover. Policies can have a deductible, they can have copays, and they can have coinsurance. And copays are like one-time fees that you pay for whatever services you're receiving, and coinsurance is usually affiliated with a percentage of the cost of the care that you're receiving. The reason that you need to buy supplemental insurances is because original Medicare does have costs that are not covered. So Medicare Part A has a deductible, which is per period, I guess, qualifying period. And so, like I said, Medicare Part A doesn't have a premium, but it does have a deductible, which is in 2020, $1,408. And these amounts go up usually a pretty small amount on an annual basis. And we haven't received the 2021 amounts yet. So for 2020, the deductible for Part A is $1,408, and that can be per period. So if you're admitted in the hospital and then released, and then readmitted 98 days after the first time you're admitted, you can be subject to another Medicare Part A deductible, another $1,408. Additionally, if you're hospitalized for more than 60 days, from days 60 to 90, if you're only on original Medicare, you're subject to a $352 daily copay. And then Medicare Part A also allows for some lifetime reserve days. So if you're hospitalized for more than 90 days, you get an additional 60 days of potential hospitalization, but you can be subject to a $704 daily copay. So if you had only original Medicare, it could be very costly if you're hospitalized. This example kind of shows how that would work if you had a first stay and a second stay and were hospitalized for a very long time. Realistically, I think most people would acknowledge that people are not in the hospital this long, but there are scenarios where people can, if they're in a coma or have other very critical health issues. So it is possible that you could be hospitalized more than 60 days. I understand that it is unlikely, but this is an illustration of what that would look like. So Medicare Part B, outpatient services, that is where most people would be most likely to incur out-of-pocket expenses if they only had original Medicare, because it's outpatient services. And again, most people receive their care through outpatient services. Medicare Part B, like I said, for most people enrolled, is $144.60 a month, the Medicare Part B premium. But again, it can be higher for higher income earners. Medicare Part B has a $198 deductible. That means that before any outpatient services are covered by Medicare, you are subject to a $198, you can be billed up to $198 in medical expenses. And then after you've reached the Part B deductible, you can be subject to a 20% coinsurance to no maximum. And that's, where, outpatient service, again, are less expensive than inpatient services, but when it's to no maximum, if you had a lot of care not while admitted in the hospital, you could be subject to a lot of out-of-pocket expenses. So, and then this also explains a little bit about how doctors receive reimbursement. And so there can be, there are doctors that accept Medicare assignment, which means that they will accept the amount that Medicare reimburses. And then there are doctors that don't accept the assignment, which is that they will bill for excess charges. And so there can be differing amounts of money that a Medicare beneficiary is subject to pay, depending on the doctor they're seeing, if they only have original Medicare. And so although Medicare is covering a lot, when you think about more expensive outpatient services, patient surgeries or MRIs or things like that, people could be subject to a lot more out-of-pocket expense. So what I do in my practice is helping people determine what type of supplemental insurances they want to enroll in when they are transitioning onto Medicare. And the first step in the process is helping people understand what it is that they're even considering to purchase. And this is a very helpful visual aid that is put out by Centers for Medicare that explains that there are two paths that people are considering when they transition to Medicare. You either purchase a Medicare supplement policy plus a freestanding drug plan, or you enroll in a Medicare Advantage plan. Now, during this open enrollment period, there are, you're being deluged with commercials on television about these different Medicare plans. And in most cases, they're advertising Medicare Advantage plans. Those are plans that people enroll in their Medicare is then administered by the private health insurance carrier that they are enrolling with. Medicare supplement policies that's the Medicare beneficiary is staying enrolled in an original Medicare, and then they're purchasing an insurance policy to cover the out-of-pocket expenses that Medicare does not cover. I will acknowledge that in this environment of Medicare products, there's a lot of interchangeable terms. And so people oftentimes are confused about what they have. And they can also be confused about what it is that they are, being marketed. So my job is to really explain the differences between the two and help people understand the pros and cons of both of the different types of policies. So Medicare Advantage, that's option 2 of the chart that I showed, is the combination of A, B, and D for most people. And I say for most people because some people who maybe get their drug benefits through the VA don't enroll in what is called an MAPD, Medicare Advantage Prescription Drug Plan. They just enroll in a Medicare Advantage plan. But most people need creditable drug coverage, so they will enroll in a Medicare Advantage prescription drug plan, which is also a Medicare Part C. This is a lot of letters. I acknowledge that, but once you kind of build the framework of understanding what you're looking at, it does start to make sense. So again, like I said, these are offered by private health insurance companies, and they're administered Medicare on behalf of Medicare. So Medicare Advantage plans cover all of the benefits of Part A and all of the benefits of Part B, and for the most part, prescription drug coverage. And a lot of them offer additional benefits that Medicare doesn't cover, like dental care, some dental care, eye exams, some benefit for glasses. And oftentimes there's a wellness component, which can be membership to a gym or sending you materials to have do health and wellness programs at home. There are a multitude of different Medicare Advantage plans across the nation. It tends that in larger population centers, there are more choices. So in some rural areas, there are not a lot of Medicare Advantage plans to choose from. But for example, in southeastern Wisconsin, where my office is in Brookfield, there are 31 different Medicare Advantage plans to choose from. And they differ, for the most part in our area, it consists of primarily HMOs and PPOs. And there are MSAs, Medicare Advantage or Medicare Savings Accounts. HMOs are health maintenance organizations, and PPOs are preferred provider organizations. And most people are familiar with that language because of their familiarity with health insurance. And the Medicare Advantage plans function oftentimes a lot like people's health insurance with HMOs and PPOs. But again, with 31 different plans to choose from, it's important to understand what plans have the features that you need to accommodate your healthcare needs. Some of the ways that Medicare Advantage plans differ, some of them have broad networks of providers, some have narrow networks of providers. All of them have a cost share for all of the care you receive, typically in the form of a copay. And the out-of-pocket expenses can differ by plan. And I was just looking this up to because there certainly could be people enrolled in our plan that are on this call that are across the country. And so, and because these plans differ so much by region, I thought it would be interesting to on average, I would say that maximum out-of-pocket in my geographic area is about $4,500 to $4,900, but the national average is about $5,000. So that's sort of interesting. If the plans offer out-of-pocket expenses, or I'm sorry, out-of-network coverage, oftentimes that is much higher than the in-network out-of-pocket max. And again, it's important to understand when you go back and look at that options chart, if you choose the path of a Medicare Advantage plan, you're always subject to the Medicare Part B premium, whether you do Advantage or Supplement. So when we kind of look at like what are people's expected expenses, the first one is Medicare Part B premium, which is paid to Social Security. And then you start to consider what the medical expenses will be. So some Medicare Advantage plans have zero premium, and some have a smaller premium, usually like $25. There are some $100 premium plans, but that's pretty unusual. With Medicare Part D, drugs, like I said, Medicare Advantage plans cover A and B, but oftentimes D. And I'm going to pause for a moment because Tom is coming on. There's a question.
Yeah, hi, Corinne. We do have a question from a viewer. The question is, when Medicare Advantage, which benefit health insurance companies, became law in 2003, how many years did that reduce the 100% solvency of Medicare according to government actuaries?
That is probably way too complicated of a question for me to answer for you. I did do some research that said that since Medicare Advantage plans have come into existence, Medicare is paying out more on average for people enrolled in Medicare Advantage plans than they are for people who enrolled on original Medicare and then have Medicare supplement policies. That's because original Medicare is not paying those expenses. The supplement is paying the out-of-pocket expenses. And that is a slide that I found from Kaiser Health. And when we get off the call as a follow-up, if there are materials that need to be sent to attendees, I'll include that slide. I think that answers your question. But I think the expectation is that with these Medicare Advantage plans, it would reduce the costs for Medicare. But it appears that, in fact, it's very close to even, but it does appear that Medicare Advantage plans or Medicare is paying out more with Advantage plans. And my understanding is that the way that Advantage plans work are that a Medicare beneficiary enrolls in the Medicare Advantage plan of their choice, and then Medicare sends the dollars allocated to that Medicare beneficiary to the private insurance carrier of their choosing. And then that insurance carrier administers that person's Medicare. And in a lot of cases, if they manage the Medicare beneficiary's health, they're paying out less claims and keeping the difference for profit. And that's really where the private insurance companies' interests lie in being a part of these programs. A lot of times they function very well for people. And I'm not saying that that's a bad thing that they're profiting necessarily, but that is sort of, I believe, how the model is meant to work, that you manage the people's healthcare, and if the population stays healthier, then the carrier makes more money. So as I was saying though, Medicare Advantage plans include drug coverage for most people, Medicare Part D. There is also the option to purchase a freestanding drug plan if you are on a Medicare supplement policy. Again, in our geographic area, southeastern Wisconsin, there are 35 different freestanding drug plans. So again, important to know what it is you're looking for when you're choosing your drug coverage. All drug plans have to have drugs in all classes of drugs, but they all have a formulary and they don't include all drugs. So what I do during open enrollment is not only help people change Medicare Advantage plans if they've disliked the plan that they've been on, but also to review their drug lists to verify that all of their medications are on the formulary for the plan the next year, and then also the pharmacies that they want to use are included in their network. And this is an interesting point too, that this slide says that Medicare Part D covers commercially available vaccines not covered by Medicare Part B. And the most common question that comes up is, or I guess maybe the most commonly sought vaccines are pneumonia, flu, those are covered under Medicare Part B, and then shingles is covered under Medicare Part D. And again, Tom has a question. Well, someone has a question. Tom's going to ask it.
Yes, I will ask it for them from a viewer, Korean. Do you need to change Advantage plans if you establish residence outside the state of Wisconsin? If so, how do you go about it?
Sure. That is addressed further in my presentation, but I'll also talk about it here. So when people move, when a Medicare beneficiary moves from one geographic area to another where their current plan is not in that service area, then they get a special enrollment period. And during that special enrollment period, they again get to go through the process that I'm going to discuss further in the presentation, which is to choose the supplemental Medicare coverage that they want to have. So that means that, like, if you would move from, say, Wisconsin to rural Kansas, oftentimes in these rural areas, there aren't as many Medicare Advantage plans, and very likely the Advantage plan that they had in Wisconsin isn't offered in that rural Kansas area. So because of that special enrollment period, that Medicare beneficiary would be eligible to even choose a supplement, which normally you would have to medically qualify to move to if you're not in your enrollment period. And I'll explain all this as we move forward in the presentation. But when people move, they get a 60-day window to make a change. And the reality is that it doesn't necessarily mean when you set foot in the new state. The driving factor is when you change your address with Social Security. So when the person moves, the first step is to change their address with Social Security. And then when that person enrolls in their new plan, the plan verifies their eligibility based on the move. And so the address needs to be updated with Social Security so that the carrier knows that the person was eligible to make the change. My clients are always posing these questions, the what ifs and how to prepare for and what to expect. And so that's a lot of what we go over as people move around. So back to Medicare drug coverage. So again, Medicare Advantage plans typically contain drug coverage, and that's a very important consideration when selecting a Medicare Advantage plan. So a lot of times, the very first cost analysis with an Advantage plan is how people's drugs are covered. Because one thing we know usually is that we're going to take our regularly prescribed medications on a daily basis. We really don't know what medical care we're going to need unless you have a regular condition you're getting treatment for. And so the drug plans within Medicare Advantage plans can have very different pricing among drugs. And that is crazy. I acknowledge that. But literally, atorvastatin, very inexpensive statin, is priced differently on all 31 drug plans. So, that usually is not a costly medication, but definitely a consideration. And there are certainly much more costly medications that you really do need to whittle down the cost of. So all drug plans, like I said, have to have drugs in all classes, but they can classify the drugs differently. So they can be on different formulary tiers. And that's something that oftentimes affects out-of-pocket expenses. So if one plan, say, for example, classifies rosuvastatin as a preferred generic and another classifies it as just a generic or a brand name generic, it could be free on one plan and $20 a month on another. So, and again, that's a low cost drug, but still a consideration. So you what you're looking at with these drug plans is, are your drugs on the formulary and where do they fall in the formulary? All drug plans have the same plan design. Once you're on Medicare for a while, it definitely does start to make more sense. I will acknowledge that it is very confusing initially. When people have inexpensive medications, they don't even realize how these drug plans are, what the framework of the drug plans are. But for people who take expensive medications, they definitely understand how this works very quickly. And so all plans can have an annual deductible. In 2020, the maximum allowed deductible was $445. All drug plans have an initial coverage phase. All drug plans have a coverage gap, otherwise known as the donut hole, and all plans have a catastrophic plan or catastrophic phase. And as you move through these phases, depending on the total cost of drugs, not necessarily what the Medicare beneficiary is paying, but what their drugs cost. So most drug plans, the deductible only applies to more expensive medications, tier 4 and 5 drugs. So if you're taking only generics, typically you're not subject to deductible. Then you exit the initial coverage phase when your total cost of drugs equals $4,020. Not that you paid that, but that your drugs cost that. Then you move into the donut hole coverage gap, where you pay a percentage cost of your medications, and you stay in the donut hole until your total cost of drugs equals $6,350. And then you move into the catastrophic phase, where you pay a much smaller percentage of the cost of your drugs or a copay, very low copay. As I said, people who take inexpensive medications never move out of the initial coverage phase, but people who take medications like biologics or insulin that is in an injector pen, or I've had some clients recently who are taking medications as cancer survivors, that those medications can cost $150,000 a year. It's not that the Medicare beneficiary is paying $150,000, but Medicare, is paying a good part of $150,000 for that drug. The Medicare beneficiary in that case has paid $15,000, and Medicare has paid the difference. So, and those people, when they take those very expensive medications, they will move into the coverage gap, the catastrophic phase in 1 month, the first month of January of the year. Yes, Tom.
Question from a viewer as to prescription drug plans. We have seen that in the same prescription drug plan, the charge for the same drug can be very different at different pharmacies. For example, $250 at CVS and $125 at Walgreens, or vice versa. So when we search for an appropriate plan, it seems wise to consider all available pharmacies, not just those the most current pharmacy. Your thoughts on that?
Yes, absolutely. I regularly say to my clients who are predominantly attorneys that the first thing you have to do is not apply logic to searching for drug costs, because it is insane to me that all 31 drug plans will negotiate different pricing on different drugs at each pharmacy. So I definitely think there's room for improvement for consumers on that issue. Tom, is there a new question or? There
is.
Follow up. Okay.
Well, you want to finish your thought?
Sure. Yeah. Okay. And as far as pharmacies go, that's absolutely true too, that some plans have preferred pharmacy relationships for a multitude of reasons. One, for example, is that Silver Scripts is actually is owned by Aetna, that has partial ownership with CVS. So they only use CVS as their preferred, or let me say, they have other pharmacies, but they absolutely do not allow you to use Walgreens. So you can see sort of that there's like this, competitive part of like the competition among the businesses too. So definitely. And I have clients who choose their pharmacies for a couple different reasons. Like if, they use their local pharmacy because it's closer to them. A lot of people want to use Walgreens because it has a drive-through. A lot of people, are also only looking for cost. So I usually look at least 3 different pharmacies in their geographic area to illustrate the difference in price. And then we consider, I just had a client yesterday who said, it's a $200 savings to change, but it's worth it to him to have the Walgreens drive-through. And that's fine with me. I just want people to know that, their cost difference exists. Yes, Tom.
Here's a comment and question from a viewer. The term you used, when you medically qualify, is synonymous with pre-existing medical conditions and can preclude an applicant from enrollment in a supplemental plan at any time other than at his or her initial Medicare enrollment, correct? And then there's a follow-up to that.
Okay. Yes. So I'll discuss medical qualifications for supplements further in the presentation, but people qualify for any Medicare plan they would like to enroll in during their initial enrollment phase. And then after that, yes, you have to medically qualify to have a Medicare supplement policy. And there certainly are medical conditions that prevent people from getting them.
This viewer had a client who didn't know that at age 77 was denied considerable coverage under his Medicare Advantage plan and tried unsuccessfully to switch to Part B with a supplemental plan because he didn't medically qualify, that is, had pre-existing medical conditions. Shouldn't this fact be clearly explained to our clients?
Yes, it should be. The information is available in, there's a booklet that most people are sent by Medicare called, it's like Getting to Know Medicare or something like that. But I do feel like, and one of the things I clarified when I started in my presentation was that today's presentation is an educational meeting. During open enrollment, when people attend seminars, and now virtually this year, I really am not 100% sure how these carriers are disseminating all the information, but most of the presentations that people attend from different carriers are actual sales meetings. And you will leave every presentation wanting to buy their plan. And you will think the most important reason why is because it offers dental and vision. But those are not the reasons that we really need supplemental insurance. And so, I find, like with my clients, I repeat myself multiple times to really make people understand what the differences are between these two plan types. Now, I will say in the case of that client, if he was enrolled in a Medicare Advantage plan, definitely anything that's medically necessary would be covered. And there's a max out of pocket that the Medicare beneficiary is subject to, regardless of if they're getting treatment for, cancer or long hospitalization. So there is a stop loss. But it is true that, you cannot insure the house when it's on fire. And I say that a lot because it's something that we kind of understand. Just like now there's open enrollment for health insurance, you can't obtain the most risk mitigating coverage when you have, assumed more risk, I guess. So it should be clear. It's in literature. I think though that a lot of people don't kind of pay attention to that fact because it doesn't apply to them until, or they don't pay attention until that issue applies to them. And then oftentimes you can't fix it. So it is an issue. I do acknowledge that. So I'm going to move forward, but I might clarify more of that question as we move forward in the presentation. So again, drug coverage. All drug plans have the same format, but they differ mostly in cost. And that's why it's important to review that. And I review Medicare drug plans on an annual basis for my clients. And I also found a statistic, again, from Kaiser Health when I was kind of doing some research, is that only 50% of Medicare beneficiaries review their drug plan every year. So that means, and I regularly find, not a lot of my clients, but like one of my clients emailed me, we're just going to stay with our plan this year. And then I, just can't, I know the repercussions of just assuming it'll be fine. So I ran my analysis and found that by changing drug plans, she would save $1,000 for the year, which, I consider real money. And some people may not, but I wanted to let her know that that was the case. And there are reports to substantiate it that come right from Medicare. And so then she did change drug plans. So oftentimes, you don't know what you don't know. And so it's important and prudent to review these things on an annual basis. So again, to be enrolled in Medicare Part D, you have to be enrolled in Medicare Part A and B, or A and B, or both. And you can be subject to pharmacy networks. Like I said, some don't allow for any use of Walgreens, or they might have standard and preferred pharmacies. So you want to find one that is a preferred pharmacy. Coverage costs vary year by year. And everybody who is on Medicare has to be enrolled in a drug plan, a creditable drug plan, or they're subject to what's called a late enrollment penalty. And we can talk more about that. But So for example, ACA health insurance is not considered creditable by Medicare. COBRA is not considered creditable. There are insurances, and if you're on a group health insurance plan because you're still working, your group health insurance is required to notify you on an annual basis if your group insurance is considered creditable. And if it's not, somebody who's of Medicare age can enroll in Medicare Part A and buy a creditable drug plan, just not to be subject to this late enrollment penalty. And the least expensive drug plan in our geographic area in southeastern Wisconsin is $7. So to pay $7 a month to not be subject to a penalty that stays with you for your whole life could be worth it in some cases. So Medicare supplement insurance, again, going back to the options chart that I first showed you, as we're going down the path to choose from, we covered Medicare Advantage plans, option 2 on the chart. Option 1 is Medicare supplement. Medicare supplement policies are purchased, that Medicare beneficiary that chooses option 1 is staying enrolled in original Medicare and buying a freestanding insurance policy that's going to cover the out-of-pocket expenses that Medicare doesn't cover, and then also enrolling in a freestanding drug plan. So Medicare supplement policies retain the features of original Medicare, which mean you can go to any doctor that accepts Medicare anywhere in the country. You do not need a referral. And since January 1st, 2020, you cannot buy a supplement that covers all of the expenses that Medicare doesn't cover, but you can buy a policy that covers almost all of the out-of-pocket expenses that Medicare doesn't cover. A federal law passed that was effective January 1st, 2020 that makes it such that you cannot buy a supplement if your Medicare Part A and B effective date is after January 1st, 2020. Your policy cannot cover the Part B deductible. That's $198. But you can buy a supplement that would make it such that the only medical expense you would have for the year would be $198. And then you could go to also any doctor. There are no networks. The only thing you have to verify is that the doctor accepts Medicare. So the plans that covered all of the out-of-pocket expenses used to be called Plan Fs. Now they're called Plan Gs if they don't cover the Part B deductible. But in the state of Wisconsin, we don't call them that. There are 3 states that don't call them that. Wisconsin's one of them. That's sort of a not important point, but a lot of times people come to me and say, like, my friend has a Plan F, and Wisconsin doesn't have Plan Fs, but we have the equivalent. So Medicare supplement plans do not pay for the Part B premium, but they do. They do cover part. You can buy riders to cover the Part A deductible, the Part B deductible. You can buy a rider to cover Part B excess charges. You can buy a foreign travel rider. You can buy a home health care rider. And when you buy all of those riders, it covers almost most of the expenses that you might have associated with your health care. It does not cover custodial care. Again, you have to buy a freestanding drug plan because it doesn't cover drug coverage. And Medicare supplement policies often don't have some of the additional benefits that Advantage plans tout, like dental or vision. But certainly Medicare covers the care and treatment of your eyeballs, so your eye care is covered. And then you can buy supplemental dental coverage if you need it. So this is a chart of all the different possibilities for buying a Medicare supplement policy. Personally, my clients, when they transition to Medicare, buy policies with all the riders that they can get, because in your initial enrollment period, you can get the richest supplement policy with no medical underwriting. You can always make your plan less rich. You can always remove riders, but you have to medically qualify to add them. So most of the time, people purchase all of the riders. You must live in the state where the supplement is offered. When you're in your initial enrollment period, so that's you're turning 65 or you're losing creditable coverage through most of the time your employer or your spouse's employer coverage, you qualify. There's no medical underwriting. It's guaranteed issue. When you're outside of your initial enrollment period, you have to medically qualify to obtain a supplement. The Premiums vary widely for the cost of supplements. So I oftentimes, I'm an independent agent, so I shop multiple carriers, and it's pretty simple. They're very apples to apples. And so there's no reason to overpay for the same thing, in my opinion. And again, you have to continue to pay your Part B premium. And I reinforce that a lot, because oftentimes people are confused and think if they enroll in an Advantage plan, they don't have to pay their Part B premium. But Part B is a part of no matter, regardless of what Medicare coverage you choose. So how do you choose? This slide gives you an idea of all the possibilities. I find that my clients choose for two different reasons. One is financial and the other is choice. And so people have to prioritize what is the most important fact to them. I will say that for the most part, I work with self-employed people or people who are, owners in their business. And if they've been paying for health insurance and they're 64 years old, 64-year-old's health insurance on average can easily cost $1,000 a month. So either being on an Advantage or a supplement plan oftentimes is going to be less expensive than being on individual health insurance. So, if doctor choice becomes then the priority with the Medicare supplement plan, you will have more doctor choice. So, what people do really comes down to, what their drug costs are, what their financial circumstance is, and what their risk tolerance is. And that's related to, are they wanting to have all of the choices of doctors, or are they willing to enroll in plans with networks? So again, okay, Tom, yes?
Question, Corinne, if I work past age 65 with credible drug coverage and my spouse is covered under my plan, does my spouse need to apply for a Part D plan when she turns 65 in order to avoid the penalty?
No. As long as you know that your plan is creditable, your spouse is covered also. So there's no need to enroll. You can enroll, and I oftentimes work with people who are still working past age 65 to look at the financial benefits of moving onto a Medicare plan. But as long as you know your Medicare or your insurance is creditable, you do not need to enroll in A, B, or D. Some people enroll in A when they turn 65 because it's confusing to understand what you might be what late enrollments penalties you could be subject to. So there's no problem enrolling in A. But because B has a premium and D has a premium, if you have creditable coverage and you have health insurance through your job, you do not need to enroll in an Advantage plan or a drug plan. So this slide kind of puts side by side, step one is people have to get enrolled in original Medicare through Social Security when they become eligible and or when they want to enroll into Medicare. Tom, go ahead. What's your question?
Yeah, Corinne, it looks like a viewer wants a clarification saying the term medically underwriting and, quote, medically qualify. He says these are euphemisms for pre-existing conditions. Attendees really need to know this for our discussions with our clients who are 65 years and over and often have health problems and are, frankly, a little bit fearful. So I guess you want to address,
Sure.
It looks like, the use of different terms and whether they're, the same.
Sure. Well, so like I said, when people are in their initial enrollment period, whether it be because they're aging onto Medicare at 65 or coming off of employer-sponsored coverage, that is your initial enrollment period. In your initial enrollment period, you do not have to medically qualify for a Medicare supplement policy, and you can enroll on an Advantage plan. When you're outside of the initial enrollment period, you do have to medically qualify to move to a supplement. And there are conditions that preclude people from enrolling on it. So I regularly talk to my clients about concerns about medically qualifying. There are medications that cause it that people can't medically qualify, and also conditions. And it's different than other insurances. It's different than life insurance. It's different, it's not as strict as some of those other insurance products. But, it's not that coverage for certain conditions would be excluded. It's that the person wouldn't even qualify for the insurance. So you're automatically accepted into original Medicare, and then people can enroll in one of, in our area, 31 different Advantage plans where no medical conditions would be excluded, but you'd have a cost share in all of the care that you receive. So, if a plan has $4,500 in out-of-pocket expenses and you're an unhealthy person, an Advantage plan might not be ideal. And also, people can become unhealthy. So if that's of concern in the future, in people's initial enrollment periods, they should choose Medicare supplements because they will mitigate more risk. You can do research, and I do it all the time because, you try and find the answer. What is the best plan? And if somebody could tell me how healthy they're going to be, I could tell you, but nobody can tell that. So, is saving money better or is mitigating more risk better? It depends on people's circumstance. And so, I would say that most people would agree that there is not a better. It depends. And it's each individual person has to do this analysis and work with somebody to conclude what is best for them. The most important thing is to work with somebody who will educate you on all the choices. Because if you're going to one sales meeting for one product, they're selling one thing and they are good at it. So you have to really understand and learn the framework of how Medicare works so that you understand what you're buying. And that's really what my job is. I'm a teacher. I teach people. I don't sell people anything. I don't want to sell people things. I want them to buy what they need. And that can change over time. And so, and that's why I work with my clients at every open enrollment. But this slide, and I'm going over my time. So this slide explains, puts it together. So there's Medicare Part A and B, and then two options that people can choose from, supplements or Advantage plans. And then there's variety within those two paths. So that is really what people are looking at when they're choosing Medicare coverage, when they're transitioning to Medicare. There are some additional slides here. It kind of gives the pros and cons. And then the end slides kind of talk about the time frame. So the initial enrollment period is you're eligible to enroll in Medicare A and B 90 days prior to your effective date, which is typically the first of the month you turn 65, but also can be when you come off employer insurance, and then the 3 months after. So that's when you can enroll and choose the plan that you want to for, with no medical underwriting. Outside of that time frame, you have to medically qualify to get a supplement plan, and you can only change Advantage plans at open enrollment. And that's actually a little bit not accurate too, because there have been some new enrollment periods added, but that's typically when people review this. So yes, Tom.
Question from a viewer, Corinne, how do we hire you and how are you compensated?
Well, you can call my office and set up a meeting, and that's how you hire me. And I am only paid by commission. I am licensed and appointed with a lot, I wouldn't say all 31 of the Advantage plans that are available in our geographic area, and there's some reasons why. And I'm licensed and appointed with a multitude of supplement carriers. There are some supplement carriers that don't allow non-captive agents to sell their products. So for example, I talked to a client in Madison, and they have Physicians Mutual, and they only allow for captive agents. So I encouraged him to get a quote for a supplement through them. I only want to get paid when I've earned your business. So, I will do consultations with people, and I will consult with people for years before they transition to Medicare. And, I have learned from my mentor, my dad, that, my time and effort in building a client relationship will pay off. And my clients stay my clients for a long time, because I think they know that, I can't explain why I've chosen to become an expert on Medicare, but I find it very interesting. I like helping people, and I think I offer a lot of value. So that's why I continue to work in this space. And I also do individual health insurance. We do dental insurance. We have a life insurance plan for attorneys. And I think that at the end of the day, I feel like we are really helping people. Although most people find insurance kind of boring, it does help families and mitigate risk and financial, offer some financial security. And so that's important. So now, if there are no additional questions, or if you have follow-up questions, you can certainly send me emails. We're going to take a 15-minute break and then do the next presentation.
Right. Yeah. Thanks, Corinne. Yeah. Thank you. Yeah. We'll be back in 15 minutes. Make sure you're back here at about 10:10, and we'll have Matt Beyer and Brian Anderson from Wilmec talking about malpractice risks. Thank you all. And thanks, Corinne.
Thanks for attending.
Welcome back, everyone. 10 after 10. We appreciate you coming back with us for hour number 2. Before we dive into hour number 2 and malpractice risks, I'm going to throw it back to Corinne just for a moment. We had a couple of folks in the first hour asking for Corinne's contact information. So, Corinne, you want to share that with us?
Sure. I didn't really introduce myself that well, I guess, because I wanted to get through my presentation. But so my name is Corinne Boltman, and my business is Boltman Financial Services, and we've had a relationship with State Bar for about 19 years. My website is www.boltmanfinancial.com, and my phone number is 262-782-9949. And so it is Medicare open enrollment, and if somebody would like to consult with me, you can call my office and schedule a time, and we can do a phone call, or any time that it's relevant for your circumstance. So thank you for attending my presentation.
And I'm sorry, did you give your email address? Do you want to do that?
My email address is cbultman@boltmanfinancial.com, and that's BULTMAN. So CBULTMAN at BULTMANfinancial.com. Thanks.
All right. Thanks, Corinne. All right. Hour number 2, malpractice risk. We have 2 speakers with us today who are going to give you everything you wanted to know, but we're afraid to ask about malpractice risk. Matt Beyer is a claims attorney at Wilmick, and Brian Anderson is our senior claims attorney at Wilmick. So Brian and Matt, it's all yours.
Hello. Thank you for attending, and thank you, Boltman, for working with Wilmick to bring this valuable information to all of the attendees today. For those of you who may not know, Wisconsin Lawyers Mutual Insurance Company was created in 1986 in response to a sharp increase in legal malpractice claims, coupled with a shortage of realistic options for professional liability insurance. Wilmick is what Wisconsin lawyers have always been, lawyers solving problems. And Wilmick's solution is to provide quality professional liability insurance coverage, superior claims administration, risk management, like today's seminar, and certainly customer service. Hopefully, you'll take away several things from today, but at the very least, know that if you do find yourself facing a claim or facts and circumstances that could give rise to a claim, please don't hesitate to call your malpractice carrier. You put yourself in a much better position to address the claim or the potential claim the sooner that your carrier has a chance to repair it. And you certainly don't want to risk losing coverage for the failure to report a claim under a claims made and reported policy. So as claims attorneys, Brian and I are here to address those kinds of situations quickly. And if we can't, we'll certainly try to help you find somebody who can. And certainly if you are not insured by Wilmick, you can still feel free to give me or Brian a call. And so we can discuss your situation. Go ahead, Brian.
Well, I was going to give people credit for open enrollment followed by legal malpractice. That's a double whammy that most people can't sit through, but we do what we can, right? We can only speak to what we know, but so this program, and my name is Brian Anderson, this is Matt Beyer. Matt put this fancy background with the cold fronts and where am I here? Green screens and all this, but this program where we're going to focus on the COVID situation and how that might be impacting claims. And honestly, we were anticipating more claims coming in with the pandemic in progress, and we haven't seen that yet. Now, we sometimes are a long tail, and we see maybe we'll see more issues next year. But so that's the good news right off the bat, is that we haven't had a lot of claim issues related to this pandemic, which we have to credit our policyholders, and we insure mostly solo and small firm lawyers, that they were ready and adaptable, and their businesses were not interrupted, it appears, from our standpoint, based on what we're not seeing, and that is problems with client communication, with getting work done and addressing their clients' needs, so I'm right off the bat, credit to the lawyers that Wilmick insures that have not had the issues that we were all anticipating. But so anyway, that's my opening line. And I think one of the things that I wanted to talk about too was that although we haven't seen the claims yet, I think one key takeaway or piece of advice that I will throw out there is to make sure that you're keeping in touch with your clients, because the solo firms are fairly adaptable. You're able to come in. It wasn't as if, I mean, Wilmec doesn't insure the 500,000, 2,000 size firm where there were real issues right away with essential business and how many people could gather in a certain place. So the solos were able to get in and continue to operate their law firms uninterrupted. But the key, I think, is making sure that your clients are able to, are their goals still the same? Are they able to function? Is their business continuing? Is the project that you were maybe starting still something that is in their best interest? And that takes a reach out and a touch base with the client to make sure that their goals are still the same, that they want to pursue the matters that you were maybe retained to undertake in light of maybe some serious changes in their family dynamics, their business, or their ability to maybe pursue certain things, real estate on down the line. Yeah, so that's one big takeaway. And the three areas that I think that we're watching the closest are estate planning, bankruptcy, and family law. And estate planning, from what we've heard on the claims end of things, there's been a real rush to get estate planning documents in order, as maybe some elderly clients are now very concerned about their welfare. And the one issue that we've heard from some practitioners, that one, the volume increased, but two, getting documents prepared, and then the client maybe not sure if they want to sign it or afraid to come in to sign things. And that's a concern whereby you want to make sure that if there's an estate planning project in place that's put together, but then the client doesn't finalize it, you want to make sure that's communicated so that the lawyer's not blamed for not better finalizing the deal. Bankruptcy, there's just been a big volume increase, and therefore there's a better opportunity for an error when there's such a volume of bankruptcy matters. And finally, a kind of a unique one that was addressed by Greg Herman when Wilmec put on a seminar this summer was in the family law arena. There may be situations where two families have entirely different COVID strategies. Maybe one family doesn't think it's a big deal, has parties, friends over, the other family is very concerned or cautious about it, and there's a split situation in terms of the placement. And it's just not something the lawyer ever anticipated when they were putting things together. And it's an unusual and unique situation whereby the attorneys maybe would be blamed for not better protecting their family when that was something they weren't even aware of at the time. But now obviously it's out there and in the news. So that's my big overview of the pandemic and how it might impact some of the areas of practice that we insure.
Yeah, I think that's right, Brian.
Yeah.
And I think I agree with you. It's very impressive how well our insured attorneys have adapted. If you just look at the Supreme Court orders between March, when we first started taking the pandemic very seriously, and now with all of the changes, even in just local court procedures, with Zoom hearings, Zoom depositions, lots of use of digital and technological advances to be able to work remotely. I think we were probably headed that way. I think there was a lot of change just because of, like we mentioned in the outline, millennial demands, and just the new reality of the capabilities of the internet and all of its opportunities to practice remotely. But it really did sort of push that issue to the forefront. So, while maybe all of the security issues and all of the capabilities weren't necessarily completely ironed out, we definitely had to address all of those things quickly. Zoom is a good example of that. I think when Zoom I had never heard of Zoom until the pandemic, and then when we started using it, there were the the notorious Zoom bombers, who came in to meetings, without having been invited, and doing all sorts of silly things. But Zoom addressed that very quickly with a pretty simple solution, and that was to allow the host of the meeting to invite the person in once they indicated they wanted to be there. If you don't know them, you don't let them in, obviously, and they can't bomb the meeting. But it really is interesting, all the different ways that practitioners have adapted. And I can think of one particular example that came up in a recent seminar, where one of the lawyers described the very situation that Brian was discussing, involving estate planning and the need to have various documents signed, with the wet ink signature. Ordinarily, I guess pre-COVID, that would usually take place by way of a meeting, where the lawyer invites the client to the office. They have a meeting, they discuss what the proposed course of the estate planning documents is, and then there's a signature at the end, obviously in an attempt to answer any questions during that meeting. But what this particular lawyer described was a more thoughtful approach to that, where the communication was had that there was a need to come in and sign a document, but let's talk about everything first. And much like when we visit doctors, we'll be in the office and the doctor will ask us if we have any questions, and on the spot, we're not necessarily able to articulate all of our concerns right at that time. But then you think about your question later and you follow up. Well, this particular drive-through signing practice sort of adopted that model, where there was a meeting explaining the documents, there was a Zoom meeting or a phone call explaining the documents, what they were, what they would accomplish. And then the client had an opportunity to digest all of that information, come up with more thoughtful questions, and then follow up with the questions, later, prior to coming in to sign the document, so that truly when the drive-through signing happened, it was literally just that, and there was a more thoughtful conversation between lawyer and client. So I don't think those things happen in other environments or in the old normal environment, but it is just an example of how attorneys can adjust, meet their ethical and professional obligations to explain their work and to consult with clients, and still be able to accomplish those things relatively efficiently. So as we work through this outline, I think we'll bring up similar examples and maybe even share some of Wilmic's own experiences to demonstrate how to handle this blend of work and life. Because I am sitting downstairs in my basement at an old dining room table. My son makes model rockets right over there. And here I am, performing my job and my responsibilities at home. But juggling those things is it's not easy always, but it is sort of demonstrating rethinking of when and where work happens. So what are some things to be concerned about? When Wilmic started working remotely, I think most of us had computers or something at home that would allow us to, remotely log into something. That's not always the safest. In fact, it isn't the safest way, to exchange pretty sensitive information. And so our IT manager, Frank Zillner, did a great job of putting together laptops and connectivity devices, including a virtual private network, so that I am looking at a laptop at home, but it's as if it's my desktop at work. I am looking at my phone that I literally brought home from the office, and it's no different than it works no differently, at least as far as I know, than it did when it was sitting on my desk at the office. So I guess with respect to setting those things up, you don't necessarily have to understand them or how they work, but you do have to understand that you need them in order to connect digitally to your workplace, your information, your client's information, and put yourself in a position to be able to protect it and keep it confidential so that you meet the requirements of the rules of professional conduct as they relate to confidentiality, and certainly keep up your ability to communicate with your client.
And I think you went, one thing I would say, I agree with Matt as far as how our setup is. I used to, though, when I left work, I did not look at emails until the next day. And now I look at them all the time. And I just want to caution that make sure that the communications are professional always and thoughtful. So if it's 9 o'clock and you're not in a great mood and your client's bugging you because they're in a tough spot, don't let your guard down and send anything less than a professional communication that's in compliance with all the SCR rules and how you would like it read back if there's a problem later. And I'm saying that because I've been in that situation where there have been things that come out late and you can't help but to think about them or have them bother you, and your knee-jerk reaction maybe isn't the best one. So the mere fact that you may be in a different setting or that your client is at home and out of work or stressed and sending you kind of aggressive communications at odd hours, don't fall into the trap of feeling you should respond in kind. And maybe make sure that is communicated, that, listen, I received your email, and remind the client that these are the times you will respond when you're best suited to do so, when you're not tired, when you're not agitated, when you're not trying to be with your family. So always check that. It may not be as different for you as the attorney as it is for your client. That's why I keep wanting to emphasize there have been some real changes, and the clients are maybe affected more than the attorney. So do appreciate that maybe the communication, you don't appreciate the way it came in from a client from their home at 9 o'clock at night or whatever the time might be, but don't let that bring you down to anything less than professional and courteous communication at all times. You'll thank yourself later. It will thank you immediately if and when there's a claim or grievance that needs to be responded to.
Yeah, you bet. And just to make sure we cover our ethics content here, Supreme Court Rule 20:1.1 and Comment 8 says this. It says that in order to meet the competency requirement, each lawyer needs to maintain the requisite knowledge and skill. A lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, to maintain the requisite knowledge and skill and benefits and risks associated with relevant technology. So Brian's absolutely right from a basic client communication standpoint. I think you do, to a certain extent, need to teach your client how to communicate with you. And while it may be more acceptable for clients as we make more and more use of technological advances to communicate with you at hours you don't want to communicate with, or it doesn't make sense, or it's inappropriate to communicate with you, there's nothing wrong with simply replying and saying, thanks for getting in touch with me. I would like to give you a more thoughtful and more meaningful response tomorrow, or by email, or by letter, so that you aren't communicating important matters by text or in some medium that doesn't make you your best lawyer. So having said those things, let's get into the rule. The rule is 1.4 as it relates to communication. What it says is that a lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent, and then I have the citation for informed consent, is required by the rules. Now, I don't think we have the text of the rule in there, but let me give it to you. So informed consent is a big deal, and sometimes just because we are in a pandemic, that doesn't mean that these rules relax at all. And so if you ever do need informed consent, I think it's important to understand what the concepts are in that definition. So informed consent is an agreement by a client to a proposed course of conduct after a lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. So sorry for the goofy emphasis on some of those words, but I think we need to unpack it a little bit. First of all, it's got to be an agreement with the client. And so that doesn't mean that you get to pick the course of conduct and that's it. It does mean that there has to be some kind of an agreement, and there has to be a reflection of that agreement with the client. So this is where I usually talk about IAY letters, but I advised you letters, but let me hold on to that for just a second. But a proposed course of conduct after a lawyer has communicated adequate information. So whenever insured attorneys contact me to talk about, informed consent, what do I need to do to get it? I will often refer, to the insured attorney to Tim Pierce or Aviva Kaiser at the State Bar Ethics Hotline to get a complete understanding of informed consent and at least have the value and the benefit of their opinion. But I think Tim's answer is almost invariably, it depends. And so it is up to the lawyer who has to communicate the adequate information and the material risks to evaluate those on a case-by-case basis. So whenever you're seeking informed consent, I think you need to make a judgment about what those things are. And then reasonably available alternatives, I think, is another one of those gray terms that gives a lot of leeway to the lawyer's judgment about what is reasonably available. Although there may be an alternative to your proposed course of conduct, it may be cost prohibitive. And then, is it arguably reasonably unavailable? I think those are the kinds of judgments that you have to make as an attorney to be an effective communicator with your client, at least as far as the rule is concerned.
And I think the I was going to say the point too, which apparently I'm stuck on this, but I'm going to keep saying it. That's a continued duty. And Matt and I did a program with Aviva at the Solo Small, all about engagement letters and laying out the scope of retention and what your duties were. But I think the perfect example is, and we have a claim like this right now, where the settlement was for $25,000 and now the client's dissatisfied. But it makes me think of this. And Matt, you and I talked about this on that program, is the insurance company offers $20,000 and representing a plaintiff in a personal injury case. And you say, no, I'm not even going to take that to my client because you previously had a conversation with your client and his bottom line was $30,000. I'm making up a number. As the attorney, that's not your call. It's the client's call. And just because early on or at the time of the initial retention, you came to agreement that 30,000 was a reasonable number and that was the number you were going to get for that client, things may have changed in that client's life. And again, I'm focusing on that, but maybe the wife's out of work, maybe the husband's out of work. There's a situation with medical bills. All of a sudden, 20,000, they need to settle that. And if you can get me, maybe they'll take 10,000. I know it's not maybe in the lawyer's best interest, and maybe you think that the case is worth more than that. But the communication is so important, and it's a continued duty that just because there was an understanding at one point in the process doesn't mean you can't communicate and understand that client's current situation, explain the pros and cons, but it's the client's decision, not the lawyer's decision. And don't forget that, and don't assume that things are the same for that client and their family during this last 9-10 months. Things that may have changed dramatically. So always check in. Never forget that it's the client's call, and your duty is to advise of the pros and cons and execute the client's decision. And so that and written communication that follows those discussions are key when a claim or grievance will arise.
Yeah, that's right, Brian. I think the better or the correct response, to an offer that you, as the lawyer, think is, let's call it a lowball offer or an unacceptable one, is not to reject it outright out of hand, but rather to respond with, well, I will take that to my client as I am obligated to do, but it will be with my recommendation that they not take it.
And then Matt, and then that communication needs to occur.
Yes.
Yes. Yeah.
Yeah, absolutely. And the other subparts of this rule, sub 2, sub 3, sub 4, and even sub 5 to a certain extent, I mentioned IAY letters. I advised you. That. So the concept is simple, and that is that there are a lot of communications that are likely to happen, perhaps now more than ever, with clients that aren't written down, and so. In order to avoid the claim down the road or the grievance down the road that is based upon poor communication. And I should, highlight, at the beginning of this page, close to 20% or over 20% of the claims that are reported to us are the result of poor client communications. And they often result from, a lack of paper, a lack of documentation that demonstrates what communication was had. So that when there is that misunderstanding, the client is not the one that's responsible for clarifying it, the lawyer is. And so those IAY letters are very, very important. And they don't always have to be a formal, formal sort of communication that's reduced to, a signed letter. I think these days we do have email and other means to communicate something in writing, but still serving the same purpose, which is a contemporaneous record of what the advice was given or what was discussed, and sometimes what was not discussed. So those contemporaneous communications, I think when we get involved in that he said, she said argument, who cares? What does the letter say if the letter is in the file? This, it would clearly demonstrate what exactly was said and what was not. So those are important, and make sure, that it's really a good way of meeting your obligations to communicate effectively with your client under Rule 1.4. So with all of those things in mind, and some of this that, we have touched on along the way here under our discussion of 1.4, but I think it's important to, before I get into those, let's see if Tom has a question.
We do have a question from a viewer, guys. What is the triggering event that should spark us to write an IAY letter to a client?
Well, if you're asking me as a claims attorney, when we're asked to defend the lawyer's conduct, I would say every single communication you ever have with. No, I say that in jest, but I think it. Anytime that a question is asked by a client, that's certainly one event that would trigger some kind of IAY letter, even if it's not an IAY letter. Is it a contemporaneous note? Sometimes I've called them Comey memos to the file, where it's just a record, a contemporaneous record of what the conversation was. I think that's a good idea. Once upon a time in law school, I worked with a public defender named Nick Bocus, and he kept a binder. It was a simple binder, and it was nothing more than, the first 2 pages were nothing more than a log of activity that happened in that file. Those are effective, but I think anytime a lawyer's advice is given, anytime a proposed course of conduct, or anytime there's an application of facts to law, I think all of those are triggering events. Brian, maybe you have more suggestions about when an IAY letter is appropriate.
I'll tell you the one thing that I'll just say and we're on the back end, and with full benefit of hindsight, when a lawyer calls and says, I knew I should have wrote that letter, but I didn't think I had to because I talked to the client, or he's a long-term client, or as a friend of mine. And another comment that we often hear is, well, I didn't want the client to be mad that I was billing him to send a letter that he already knew what I told him. But so that don't bill it, do a no charge, but just a simple letter always. But especially I say where that letter comes in, that the question was, anytime that a client decides not to follow your advice, and that seems basic, but really, for example, we've seen claims where an appraisal wasn't, the lawyer recommended that the property be appraised, and the client says, no, I don't want to pay for that. that's fine. But there's where a letter would be very helpful when later the property ends up being far more valuable than maybe it was attributed at the time of the divorce, for example, or an estate matter. You want to make sure you're saying, I appreciate that. You don't want to pay for an appraisal. I recommended it. Put it in writing, because that's going to be hugely important if there's first of all, it's your actual advice, but secondly, that will protect you so much better, because when it's not in writing and there's a substantial difference in property value down the road, unfortunately, the tie does not go to the attorney. It goes to the client when it's not in writing. And that simple letter can be the difference between a claim or no claim, or agreements or no agreements. And maybe it's defensible in the end, but $20,000, $30,000, $40,000 in attorney's fees and defense costs and depositions for that one letter. Send it always when a client doesn't have to take your advice, but make sure you're documenting the advice you did provide.
Yeah, thanks, Brian. That reminded me of another situation that we are made aware of from time to time, and that is that when a client comes to you and they've got the deal all worked out and they just need somebody to help paper it, make sure that, because undoubtedly, the best situation an attorney can put him or herself in, and the best service to be provided to the client would be, a full and thorough and complete representation. But when the client comes to you and wants to limit costs, or wants to limit, your involvement as the attorney so as not to sour the deal, for example, I think it needs to be made clear, and that's a perfect opportunity for an IAY letter. Look, you came to me, you asked me to do this. My recommendation was to do this. And this is along the lines of Brian's suggestion that anytime they don't take your advice is a good time for an IAY letter. Similarly, when they limit your scope of representation, that needs to be made clear that they did it, not you. And sometimes that's not always captured in the engagement letter, and needs to be followed up or supplemented with an IAY letter.
Yeah, that's a good point. That we have definitely seen the claims where the land contracts put together and there's no title work done. And just to verify, I will help you with this, but I would recommend X, Y, and Z. I agree, Matt. We actually had a trial over that very issue. So, and the lawyer was very glad that they did write that letter in that case.
Exactly. So a couple of pointers. One, reach out to clients proactively. Don't leave them guessing. One of the most refreshing occurrences during this pandemic for me was to get communication from, we work with a lot of defense counsel. I mean, that's obvious. But almost every one of them, and sometimes at our urging, but more often than not on their own volition, they would contact us to let us know how we could reach them. And so this gets to point 4 as well, so that when we initially had the stay-at-home orders, many of us had to work initially with our cell phones, and by other contact points that weren't readily available or weren't known by those that we were serving. And so getting that communication, early, so that it would be easy to contact our attorneys or you as attorneys, your clients, make it easy for them to find out where you are. And then, perhaps more importantly, follow through and be available at all of those numbers if that's where you want to be made available. That's part of teaching the client how to communicate with you, is make sure they know how to do that. Looks like we might have another question. Oh, go ahead, Brian.
Well, I was going to say that the other purpose of doing that is to make sure where the client, that you're able to catch up with your client, because there have been cases where the clients moved out of state because of situations going on, and it just helps you make sure you're available to them and vice versa, that you can reach them when needed.
Back to your, you guys talking about putting it in writing. One viewer comments, I think they live by the credo, if it's not in writing, it didn't happen.
Yeah, and this is getting old, but I sat through a mock jury and at an ABA PL conference, and that's exactly, Tom, what jurors said that in there, we got to sit through their deliberation, and that exact comment was when they were talking amongst themselves. If a lawyer doesn't put something in writing, that was the quote. So they did not believe the credible lawyer who testified because there was no written proof of the conversation. And written, as Matt points out, easy to send an email that's tough because that can be done so quickly and easily.
Yeah, I think, Brian, you're breaking up a little bit, so I'm just going to jump in. I hope I'm not talking over you.
Are you still there? You look like you froze up for a second. Oh.
Okay.
I'm
not sure if it's on your end or mine, but
can you hear me?
Well, I'm just gonna keep going forward here, and I think Brian's there. But in any event,
Yeah, are you?
There you are. Then you're frozen again. Here we go. These are some of the challenges that you get by trying to stay connected at home and then on lots of different bandwidth. But in any event, in writing is important. And I think Brian was making the point correctly. And that is that if it isn't in writing, it isn't, as our attendee indicated in their email question. Another way to write it down is and one of the things that you're probably guaranteed that your client is going to read is your bill. And so, I always appreciate bills that are a bit more thorough, in the description of what the lawyer did. And so if that's an appropriate place to put it, go ahead and do that, because that will certainly describe why you're being paid. It will certainly describe what exactly the nature of the discussion was, and be an accurate reflection of what was discussed. Tom, are you? Do we have another question?
We do, and a couple of comments. Yeah, the pictures have broken up just a little bit. We haven't lost video of you guys, just a little freezing up here or there, but we're just to the viewers, we're doing our best to keep this going. So we will do that. And then a question from a viewer: text messages. I see a lot of divorce and criminal lawyers conduct business with clients by text message. It's ubiquitous, but many phones auto delete texts after a certain number of days. If you do business by text, you need to save them somehow. I think that's a good point. I know it's one I've heard both of you make is when you want to commemorate written communication for historical purposes, text messages, you want to commit those to some other form of writing. Am I correct?
Yeah, no, that's absolutely right, Tom. And I think whenever there is a text message, or whenever we start to talk about text messages, there's often the question: how do I preserve all of these text messages? And I think my knee-jerk response is often to say, don't communicate by text, which at least not anything substantive. I think that's a difficult response given the way that clients want to communicate and the client's expectations. But I think, as I've put on the screen here, I think one of our jobs as lawyers is to manage those expectations. And so stay on top of that. If you have to communicate by text, do it. There are ways, it's simple, at least on my iPhone, there are simple copy and paste means by which you can preserve those text messages. And simply convert them into notes, which then become printable. Those are easy solutions, but that becomes cumbersome, I think, especially when we have much better options and much better cataloging and indexing options available to us by way of email or our own file and record keeping software. I don't know that there's a perfect seamless transition between all of the modes of communication just yet. But there are ways to preserve those things, and it is very important, as the attendee notes. I think clients just want to do that, and so they will. And so your job is obviously to preserve those things so that documentation occurs.
Hey, Matt, am I back on the screen for you now?
Loud and clear now, Brian.
Okay, I moved to a different venue.
There you go.
And I would reiterate what I mentioned at the beginning. I don't mind the text, but double check before you send it. Is that what you want to send? I mean, it sets up for a potentially less than professional communication sometimes, especially if you're on the run and you're kind of irritated. Maybe it's not the best time to text back, or if you do, double check it. Is that really what I want to send? And then maybe it is, and then that's great. It's a written communication, but it is a written communication, so you want to make sure it's professional.
Yeah. So moving on, we've got 9 minutes here to get through the rest of our outline, Brian. I'm not sure we're going to do it, but jump in with anything that you think we've got to cover.
Yeah, Matt, where are we at here? Page.
I'm going to go to.
I'm way beyond.
I'm going to go to page 5 here, where we talk about suing for fees. I think Wilmec takes a slightly different approach here to suing for fees than some other carriers might. I have worked at firms where suit for fees either counts as a debit against you or is a cause for dropping you as an insured. Wilmec doesn't do that. Wilmec recognizes that your skill in trade is your time and your effort, and you ought to be paid for that. But we would be remiss if we did not identify the risks associated with suing for fees. And so what we would encourage at Wilmec, when I have this conversation with insured attorneys, it's to ask, this series of questions on page 5. Was the client pleased with the outcome of the case? Obviously, the answer to that could be quite obvious. But what's coupled with that is, was there some kind of warning? Was there some kind of expectation management done by the attorney to be sure that the client understood that there is no guaranteed case you can lose, and it may not go the way you want it to? And so were they at least pleased with your communication and your level of judgment about the outcome of the case? Are you critical of your own performance? Oftentimes we'll get calls where an insured attorney says, man, I can't believe I made this mistake, or something like that. It didn't really affect the outcome of the case, but it's something that was there. And has an uninvolved attorney assessed your representation? A lot of times that's difficult for solo practitioners, to have an uninvolved attorney, but I'm on the solo small firm general practice board, and oftentimes we emphasize the importance of establishing a network of other attorneys that you can consult with those kinds of questions. And what's the amount at stake? Are we going to get, a judgment for $500, and risk, a counterclaim of malpractice? Maybe it's not quite worth it then. And is there an alternative? Maybe it's just that the client is in a current situation where they can't pay the entire sum at once. And is that something that can be worked out by way of a payment plan? And I already talked about, how some carriers might handle that claim. Again, Wilmec doesn't, we have to identify the risks, but, it's not something that we would necessarily count against you. And then would a judgment be collectible? Again, is that idea of, if you get a judgment, do you just frame it and put it on your wall? Or is it something that you can actually get payment from down the road?
I said, Matt, I would add that to the outline, which I'm going to do right now from our program the other day. The final question is your billing, is the suit in compliance with your billing agreement with your client? And Aviva was wise. It's nice enough to offer that she would review a fee contract prior to filing suit, if that's what you're planning to do, because there are certain contracts that maybe where lawyers have gotten in trouble where they've added cost or interest or things like that into a suit that is not in compliance with their underlying fee agreement and may not be in compliance with the SCR rules. So I would say one more cautionary note: hey, you're paying your state bar dues. Might as well use the State Bar Ethics Council to make sure you're in compliance with your fee agreement before filing a suit.
So speaking of, with respect to fees, the rule is long. I'm not going to read it to you. We certainly don't have time for that. But just take away a couple of points here from, generally from the rule 1.5 that governs fees. And that is, one, if the matter is going to involve $1,000 in fees or less, you certainly still need to communicate with your client about the terms of representation and what you're going to charge, all of those things. And it can be oral or in writing. Obviously, I'm here to tell you that it's preferable to have it in writing, but it doesn't have to be if it's a small matter and it's $1,000 or less. If it's going to be more than $1,000, then I think, I know that the rule requires that the communication regarding the agreement, the service agreement, has to be in writing. It doesn't necessarily have to be signed. It doesn't have to be signed by the client, but it does have to be communicated in writing. And then for any contingency fee matter, that is the type of agreement that does need to be in writing, and it needs to be signed by the client. So two different requirements there as far as the rule is concerned. So please be aware of those things as you enter into those different kinds of agreements. And again, as Brian just said, very important to make use of the resources available to you at the state bar. Aviva is super smart. She seems to have developed some kind of specialty with respect to fees and fee agreements and trust account management and all of those types of concerns when it comes to fee agreements. And I'm sure that she would be willing to talk to any of you. So please give Aviva and or Tim a call at the State Bar Ethics Hotline to make sure that your fee agreement is what it's supposed to be under 20:1.5.
Yeah, the quick thing on the contingency, which has caused problems for lawyers we insure over the years, is that if you want to work with another attorney in a different firm on a fee sharing agreement on a contingency fee case, you're going to be treated as if you're partners in the same firm if there's an error that occurs. So if you are maintaining a fee interest in a contingency fee matter, maintain connection with the client and the case, because you're going to be held to the standards if you were handling it, even though you may not be. That, and the other quick point, that you cannot, if you are to resolve a fee issue with the client may be upset. You cannot have them waive their right to maybe file a grievance even after you've reached an agreement. They have the right to do that. So you cannot ask the client to contract away the right to file a grievance, even if you have reached an accord.
There you go.
Nuances in the OLR. We didn't put those in, man. We're just reporting.
That's right.
We're probably getting close to it.
We are. I've got another 2 minutes, and I'll get through some of these as quickly as I can.
Okay.
Jump in anytime, Brian. But 1.1, competence. So
sure.
This rule really, we're not here to tell you not to dabble, but dabble meaning, well, let me back up. Don't dabble, but let's define dabble. Okay. Dabble means that you're going into a case without having established yourself as somebody who knows what the heck they're doing. And in other words, you're not competent in that area of law. But I'm not going to tell you as a lawyer that you shouldn't take on a case in a new area of law if you want to practice in that area of law. Just use what resources you have available to you, including yourself, your knowledge, your skills, and study. Make yourself competent in that area if it's new to you. And another way to make yourself competent in an area is to associate with somebody. Again, back to the importance of that networking requirement for solo and small firm lawyers. Make sure that you make yourself or that you avail yourself of people who have this skill, the knowledge and the experience in that area of law, so that you do it and you do it correctly. So with that clarification, don't dabble, but obviously you got to be a lawyer.
And I think the other way that happens, Matt, what we see on our end is that you were retained to handle a real estate matter. Mixed within the problem, the client is having maybe a family law, personal injury, estate planning issue that pops up. So you get dragged in inadvertently into an area of practice that you're not even comfortable in, and maybe not even believing that you're practicing in for that client. that's where the importance of saying what you are and are not going to do for the client is so important. So you're not assumed to be dabbling in an area that you didn't even realize you were helping the client with.
Very true. Another good point for communication too. So,
Yep.
Tom, we either have a question or you're going to give us the hook.
No, a question, a comment, back to your previous discussion. A viewer says a good idea to add a clause that if they file a grievance post-settlement, they forfeit the settlement. Do you guys want to comment on that?
Not sure that's Matt, I don't believe that is in compliance with the SCR rule on that, because that would basically be you're asking the client to waive the right to file a grievance as a part of the settlement, which you can't do under the SCR rules.
I think that's a condition that would violate the prohibition on any sort of clause that would limit the client's ability to file a grievance with OLR.
Yeah, and by the way, this is different than a legal malpractice claim that they can waive and sign their rights away so long as they've been advised of the right to review the matter with counsel. So a legal malpractice claim is different in the SCR's rule than a grievance. So I'm only specifically talking about you cannot, as a condition of a resolution, have the waiver of a grievance matter, which is it's a strange little nuance in the SCR rules. Well,
yeah, I agree with you, Brian, and I would even go one step further in the malpractice piece, and this is where I don't think you can beforehand sort of negotiate away the client's ability to bring a malpractice action even against you unless they have independent counsel on entering into that kind of an agreement. That's a sticky one. I don't know that I would. I certainly.
And I would just say to that who asked that question, I've only once since I've been at Wilmec 17 years, and there's only been one time that a resolution after a resolution of grievance was filed. So it's usually the resolution ends the grievance, but be careful that you're not running afoul of the SCR rules by including a waiver of a grievance, which the client always has the right to pursue.
Yeah, I would love to have Aviva's response to that, but that's what I would guess that she would say.
Yes.
So I think we are past our time, but I wanted to thank everybody for listening and thank you to Boltman and Corrine for inviting us to participate in this seminar. And I don't know if Tom is still with us or not, but do you have any closing remarks as I give myself the hook here and let everybody off, having earned their ethics credit?
Yeah, thanks, you guys. Brian and Matt, both, thank you. Some really good stuff there. And my advice to viewers is if you have any further follow-up questions for Brian or Matt, feel free to email them at Wilmec, brian.anderson@wilmec.com or matt.beier, BEIER, @wilmec.com. And Corrine, thank you as well. And thank you for having us. And Corine's email, for those of you from the first hour, cbultman, CBULTMAN, @bultmanfinancial.com. Am I right about that, Corrine?
Yes, you are right about that. Thank
All
you
right, excellent.
for attending.
Yeah, so thank you. As Matt said, Corrine, thank you for inviting us to do this with you, and thank you to the viewers for sticking with us for a couple hours. All really good stuff today, and I'm sure we'll do it again sometime in the future. Sorry we couldn't be in person with you today, but with the pandemic, this is the next best thing, and it's good that we can at least do it this way. It's the next best thing to being there, right, as they say. So Thank you very much. Corrine, any closing comments from you?
No, hopefully we'll be doing some additional seminars in the near future. So we'll keep everybody who attended posted. And other than that, everybody stay safe.
I had one question right near the end here. A viewer asked if it qualifies for an ethics credit, and I believe hour number 2, Brian and Matt's presentation, does include an ethics credit. So you should be good. When you report your credits to the BBE and you do it electronically, you want to, when you get to that reporting page, click on the dot that says live webcast. Okay, you got to make sure you click live webcast, and that will take you to the list of programs that that are doing it this way, webinars, and that's where you'll find this program. So make sure if you don't click on live webcast, you won't find it. So be sure you do that. And if you have any other questions about it, you can contact me at Wilmick, tom.watson@wilmick.com. All right. Any other comments from anyone? Brian, Matt, Corrine, thank you so much.
No,
Yeah,
Corrine.
Go ahead.
Oh, I was just wondering when's Corrine sending over lunch for us?
Real
For all
quick,
250.
It'll be arriving by DoorDash momentarily.
Okay.
Just kidding.
All right.
Phil
Thank you,
and
everybody.
State Bar, thank you very much for making it technologically possible.
Yeah, Phil Hinkle at the bar. Kudos to you for making this happen. Appreciate it.
Yes.
All right.
Thank you.
Thank you all very much. Have a good
Bye,
Wednesday
everybody.
and a good rest of the week. Bye now.
Thank you.
Take care.